This hearing of the Task Force on Defending Constitutional Rights and Exposing Institutional Abuses will come to order. Welcome, everybody. Thank you all for being here. Without objection, the chair may declare recess at any time. I now recognize myself for the purpose of making an opening statement. The rule of law and equal access to justice for Americans are bedrock principles enshrined in the Constitution. Access to our legal system and the rights and freedoms we enjoy as Americans as a result of the rule of law are fundamental components of the success of our nation as we celebrate the 250th anniversary of the Declaration of Independence. So it should concern all Americans that these principles are eroded by discriminatory DEI practices, and concern them even more that these DEI policies have been promoted by attorneys with the legal training to know better. The ABA as an institution plays an outsized role in American law and the legal profession. Ever since it was founded in 1878, the ABA has grown to be the entity that sets the accreditation standards for American law schools. Since 1952, the ABA has been recognized by the federal government as the only law school accreditor. Those state Supreme Courts have the power to regulate the conduct of legal professionals within those states. Many states also recognize the ABA as the accreditor for their law schools. Furthermore, the ABA evaluates judicial nominees, promulgates model rules of professional conduct for attorneys, and speaks for many people as a voice for attorneys in the United States. So what has the ABA done with this impressive accumulation of power and prestige? Unfortunately, it appears that the ABA, ideologically captured by radical leftists, has continuously pursued discriminatory DEI practices. This included requiring law schools to consider race as a factor for admissions and to evaluate racial discrimination over a merit in order to diversify the profession. This wasn't done in secret. The ABA published an accreditation standard to enforce it. That's Standard 206. And the implementing guidance for Standard 206 says that even if those DEI practices are illegal under a constitutional provision or statute, that illegality is, quote, not a justification for a school's noncompliance with Standard 206, end quote. Even after the Supreme Court held in 2023 that race-based admissions practices violate the Equal Protection Clause of the 14th Amendment to the U.S. Constitution, the ABA did not voluntarily reverse course. Instead, it doubled down and told law schools it would continue to enforce its DEI standards in the accreditation process. Through Accreditation Standard 206 and Standard 303C, the ABA used its institutional power to bully law schools to also require mandatory DEI-related courses in addition to instituting race-based policies and admissions. As we heard from witnesses during our hearing on July 14th, discriminatory DEI policies, in addition to being illegal, seek to pit Americans against one another on account of their immutable characteristics, and at their core, fundamentally reject the American ideal of equal justice and of achieving success based on one's merit. The ABA, an organization made up of attorneys who should know better, persisted in promoting DEI practices even though race-based admissions, forced speech, and considering race in employment decisions clearly violate the law. Those practices violate federal civil rights statutes passed by Congress more than 60 years ago, in addition to violating the U.S. Constitution. It wasn't until President Trump issued executive orders and threatened the ABA's accreditation monopoly at the federal level that the ABA begrudgingly started to assess whether to get rid of those DEI requirements. Enforcement of Standard 206 on DEI and admissions is currently suspended, and although the ABA Standards Committee recently recommended that it be repealed, it received numerous comments still supporting keeping DEI in full force, and the full repeal has not yet taken effect. Standard 303C on DEI-related mandatory coursework remains in force, and although the Accreditation Committee is reviewing that standard as well, no final decision has been made. Meanwhile, the ABA devotes entire pages on its public-facing website to promoting DEI in the legal profession, leaving me, for one, skeptical that it has learned the error of its ways and will make a clean break from its racist DEI policies. ABA President Benke even stated in February of this year when speaking to the ABA delegates that, quote, "We will not abandon our commitment to diversity, equity, and inclusion," end quote. Given this reality, it's no surprise that many states like Florida, Texas, Alabama, and Tennessee are moving away or considering moving away from the traditional monopoly in law school accreditations exercised by the ABA. Our purpose today is to examine the role and future of an institution like the ABA in law school accreditation and in the legal profession in our country. The harm that DEI has caused to the legal profession and to Americans who deserve equal access to justice and competent representation from their legal professionals is extensive. We must ensure a course of action that will restore merit and integrity to American law and the legal profession. And with that, I yield to Ranking Member Simon for her opening statement.
Thank you, Mr. Chairman, and thank you to the witnesses and to the public who's joined us today for this conversation. You know, before the witnesses begin, I want to talk to this room about what you're going to hear in the next hour, because the script is not new. We'll hear that a private, independent association of attorneys is the great racial menace of our age. We will hear the word merit spoken as if opportunity has ever truly been distributed by merit in this country, and we will hear that a diversity standard already suspended and repealed somehow still threatens the republic. The majority has convened the machinery of the United States Congress to prosecute a rule that no longer is in question at an institution that has already capitulated to the President of the United States, and they call this exercise oversight. It's not oversight, it's theater, because let's be clear. If you read the bylaws of said organization, if we look at organizational charts of said organization, the council that sets up accreditation standards is separate from the ABA professional organization here today. It exists to ensure that lawyers are qualified and ethical. But we all know that qualified and ethical attorneys and judges are often on the front lines of protecting Americans, of preventing the Trump administration from violating Americans' rights and the rule of law. So I ask, and I think it's an important question, is this conversation helping Americans? Last year, fewer than 1 in 10,000 Americans applied to an ABA accredited law school. That's 0.02% of the population, yet this is what the majority chooses to investigate today. While 10 million Americans will lose their health insurance because of the law that the majority wrote just last year, which made the deepest cuts in Medicaid in our country's history. The American Bar Association cast no vote on that bill, but 209 Republicans did. 4 million people have already lost their food assistance faster than the Congressional Budget Office predicted. This Congress ordered a 64-year-old woman to prove her work hours before she could keep groceries on the table. It ended exemptions for our veterans, people experiencing homelessness, and children aging out of foster care. No bar association wrote a word of it, but the Republicans did. 5,843 NIH grants have been terminated or frozen. 383 clinical trials, and we all know who are in clinical trials, were stopped midstream by this administration, and more than 74,000 people enrolled were sent home. Those are folks fighting cancer, ALS, children struggling and waiting for another call of a possible clinical trial, only again to be turned away because of this administration's actions. And the Trump administration decided with all of those 74,000 people that their lives weren't worth it. More than 100 schoolgirls are buried beneath the rubble from American munitions in a war that no Americans asked for, but no lawyers association put those babies in the ground. My colleagues, however, financed it. So, if the American Bar Association did none of those things, Why is the American Bar Association on deck? I will tell you why. Because they sued the president. When lawyers were stripped of their security clearances for representing his critics, when law firms were pressed into nearly $1 billion in tribute to our president, the ABA went to federal court, and judge after judge ruled that the administration's actions were unconstitutional. The government lawyers argued only that no one had standing to sue. So the hearing that you're in today is an answer to that lawsuit. A task force with the word constitutional in its title has been assembled to collect a political debt for the president, a president that the courts keep ruling against. And since the majority insist on talking about racism, let's consult the record. In 1912, the ABA expelled 3 Black lawyers it had admitted by mistake, including William H. Lewis, then the Assistant General Attorney of the United States, because of its settled practice to only admit white men. After public outrage, the ABA reinstated them. Then it amended its application process so that every future applicant had to declare their race. It knowingly admitted no other Black lawyers for another 3 decades. So the diversity standard on trial today was a part of the ABA's effort to reckon with that history. The majority arrives a century late, silent about the discrimination, yet furious about its repair. The Constitution is not endangered because more Americans entered the legal profession. It is endangered when power is used to punish those who challenge it, when oversight becomes retaliation, and when Congress mistakes grievance for governance. History will remember which side that choice we stood on, and I yield back. Thank you, Mr. Chairman.
Thank you, Ranking Member Simon. And now I'd like to welcome our witnesses once again. Thank you all for being here. First, we have Michelle Binky, President of the American Bar Association. President Binky has held her position since 2024, and prior to that served in various other leadership positions within the ABA, including serving as chair of the ABA Commission on Racial and Ethnic Diversity in the profession. Second, we have Zach Smith, Senior Legal Fellow of Courts and the Constitution at the Heritage Foundation's Legal Policy Center. Next, we have David Blackman, a Texas State Guard veteran and former student from Penn State University Law School who is directly affected by DEI radicalism in his law school. Thank you all for joining us, and I look forward to your testimony. Pursuant to Committee Rule 9G, the witnesses will please stand and raise their right hand. Do you solemnly swear or affirm that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Let the record show that the witnesses answered in the affirmative. Thank you. You can take a seat. We appreciate you being here today and look forward to your testimony. Let me remind the witnesses that we will have read your written statement, and it will appear in full in the hearing record. Please limit your oral statement to 5 minutes. As a reminder, please press the button on the microphone in front of you so that it is on and the members can hear you. When you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow. When the red light comes on, your 5 minutes have expired, and we would ask that you please wrap up. I now recognize President Binky for her opening statement.
Good afternoon, Chairman Gill, Ranking Member Simon, and distinguished members of the task force. Thank you for the opportunity to be here today. My name is Michelle Banky, and I am serving as the president of the American Bar Association, a nonpartisan membership organization open to all American lawyers. I practice law in Madison, Wisconsin, where my husband and I have raised our 2 now adult children. I've been a lawyer for almost 40 years, focusing on real estate, business, and estate planning. I began my 1-year term as president of the ABA last August. Each and every day, I put on this pin, and I am proud to represent our 250,000 members from every state across the country and all walks of life. Our members come from red states and blue states. They range from solo practitioners to lawyers in big firms. And their practices include everything from family law to criminal defense to commercial contracts and litigation. When the ABA, as an organization, takes a position, it reflects the considered judgment of this diverse membership. The ABA has been carrying out its mission to serve and strengthen the American legal system for nearly 150 years. As the national representative and voice of the legal profession, we are dedicated to serving the legal community and the public by defending liberty and pursuing justice. The rule of law does not defend itself. Lawyers do. And that's why I've chosen to serve. It's also the reason I'd like to address the subject of today's hearing. The ABA is deeply committed to fostering a justice system that everyone in America can have access to and confidence in. When our practice is open and inclusive and unbiased, we attract a wider range of talent and perspectives. Diversity and excellence are not mutually exclusive. In fact, the opposite is true. Diversity, equity, and inclusion initiatives enhance merit within the legal profession. When we have diverse teams, our profession is stronger. It enhances our ability to solve our clients' problems. When we can tap into the varied experiences and perspectives of people from every background and every community. When someone asks me whether we've arrived at a truly open profession, I think back to my parents. When Brown versus Board of Education was decided in 1954, the decision that dismantled the legal framework of separate but equal, my mom and dad were just 12 years old, living in Mississippi. Segregation and legalized racial discrimination shaped the world they grew up in. Their daughter later became the first Black woman elected to serve as president of the State Bar of Wisconsin, and now I sit before you as the president of the American Bar Association. Our story is proof that there has been progress, but the numbers tell us that there's still more work to do. The data shows that women, lawyers of color, and other groups remain drastically underrepresented in the American legal community. Barriers still remain. Barriers that prevent talented individuals from pursuing legal careers and rising within the profession once they enter it. Working to identify and reduce those barriers enhances merit within the profession itself by ensuring everyone has the opportunity to bring their capabilities to the practice of law. That is what true meritocracy looks like, and that is what the ABA strives toward. Next, I'd like to talk about the importance of a national law school accreditation to the American legal system. The Council of the ABA's section on legal education and admission to the bar has been recognized by the Department of Education as the national accrediting body for JD programs for more than 70 years. The Council is separate and independent from the ABA, and this separation is legally required by the Department of Education. So while I can't speak for the Council, I can tell you what the Council's work means for the American public and potential law students. When someone enters a lawyer's office facing divorce or criminal charge or a business dispute, they don't have the opportunity to audit the lawyer's legal education. They have to trust that the lawyer received a quality education. The accreditation system is what makes that trust possible. The Council's accreditation system is also a promise to every law student that their degree will be portable and that they will have the opportunity to practice in any state, not just where they went to law school. In closing, I'd like to underscore, at the ABA, we believe in a legal profession that is open to anyone with the talent and drive to serve, and we believe in the rule of law that guarantees the fundamental rights of every American. Thank you again for the opportunity to appear.
Thank you, and I now recognize Zach Smith for his opening statement.
Thank you, Chairman Gill, Ranking Member Simon, members of the committee for this opportunity to testify before you today. The American Bar Association has abandoned its mission to provide best practices for the legal profession. Instead, it has opted to push a partisan program full of radical policies. For example, the ABA has weighed in on hot-button cultural issues by supporting nationwide abortion and racial discrimination at American universities. It has opposed Second Amendment rights and has attacked states that refuse to let children cut off their genitals if they feel they were born in the wrong body. Even more egregiously, for an organization supposedly dedicated to the rule of law, it has taken the absurd and patently incorrect position that our Constitution has 28 instead of 27 amendments. This position that the Equal Rights Amendment has become part of our Constitution is so egregious that even the Biden-appointed Archivist of the United States, the official that certifies newly enacted constitutional amendments, rejected it out of hand. As a private organization, the ABA is free to adopt almost any policy it wishes, but the federal government recognizes the ABA's Council of the Section of Legal Education and Admissions to the Bar as the sole federally recognized law school accreditor. And when this entity, which is nominally under the auspices of the ABA, exercises government-sanctioned authority, it must comport with the Constitution. But it doesn't. In fact, as current President Michelle Benke made clear in a February 2026 speech, the ABA will not abandon its commitment to diversity, equity, and inclusion because now is not the time to take back the progress that we have made. And she delivered introductory remarks at the ABA's 2026 Equity Summit, which the ABA Diversity, Equity, and Inclusion Center hosted in coordination with the ABA's DEI Advisory Council. The summit included panels with titles like Disparate Impact Liability and Old Innovation That Remains Advantageous, Beyond Rainbow Logos Centering LGBTQ+ voices who fuel innovation, equity, and better lawyering, and Professional Conduct in a Fractured Climate, Model Rule 8.4G, DEI Challenges, and Ethical Lawyering. Now, for those unfamiliar with the ABA's Model Rule 8.4G, it's a chilling speech code put forward by the ABA under the guise of policing the professionalism of lawyers. But it has drawn condemnation from across the political spectrum, and one Pennsylvania federal court found that Pennsylvania's version of this professional conduct rule, which was based on the ABA's model, was unconstitutional, though that case was later dismissed for other reasons. While the council is supposed to be nominally independent from the larger ABA, there are very real reasons to question just how independent the council really is, given the co-branding and Byzantine relationship between the two entities. Even setting aside that overlap, the council itself has taken a number of controversial actions, including targeting law schools such as George Mason or St. Thomas for not implementing its radical DEI and other progressive policies aggressively enough. Now that it's facing an existential crisis and the loss of its monopoly on law school accreditation, the council seeks to back away from some of its most egregious positions. Consider, as we heard, that it now seeks to repeal Accreditation Standard 206, which requires law schools to demonstrate by concrete action a commitment to diversity and inclusion, which it interpreted as requiring law schools to treat students, faculty, and staff differently based on their race. But the council isn't making this move having reevaluated its position or even after having reevaluated the proper role of an accreditor. It's making this move out of crass self-preservation. When it perceived the political winds to be blowing in a different direction several years ago, the council demanded that law schools comply with Standard 206 even if constitutional or statutory provisions required otherwise. In other words, the council said its rules trump the Constitution. That's shocking. So what's to be done? First, Congress and the executive branch should build on the good work that has been done and eliminate the ABA as the sole law school accreditor. Congress should update relevant statutory provisions to prohibit the recognition of any accreditor that imposes DEI requirements, and Congress should build on the work of states that have eliminated the ABA as the gatekeeper to state bar exams. If other states continue to rely solely on the ABA for this function, Congress should strip those states of relevant federal funds. As Justice John Marshall Harlan had the foresight and fortitude to make clear 130 years ago, our Constitution is colorblind and neither knows nor tolerates classes among citizens. But the ABA has been using its accrediting authority to undermine these constitutional commitments to equal treatment regardless of race. In closing, the federal government and states must continue to take actions to end the ABA's monopolistic status as a law school accreditor. Thank you.
Thank you, and I now recognize David Blackman for his opening statement.
Chairman Gill, Ranking Member Simon, honored task force members, I thank you for the honor of speaking before you today and the ability to tell my story. I will not spend much time on the specifics of my departure from Dickinson Law, seeing as those events are well in the public record. However, I want to be clear about who I am and why I walked away. When I served as a 911 dispatcher in Texas, I operated under a system of objective rules and clear standards. I went to law school believing the legal profession held that same reverence for objective truth. I was wrong. I did not leave because the coursework was too difficult. I left and pivoted my career because I realized the institution was demanding ideological conformity over objective legal analysis. In the world of business school, we deal in facts, concrete frameworks, and strict compliance. But on our law schools, this framework has been replaced by a political litmus test. The American Bar Association has done more damage to the neutral administration of our laws than any other institution in modern America. The impact of Standards 206 and 303C will be felt for a generation. This is, without a doubt, the biggest implementation of mandatory DEI in higher education across our nation, touching the lives of every law student who chooses to walk the path of Abraham Lincoln and Thurgood Marshall. Make no mistake, members of Congress, DEI does not care for the opinions of the police officer, nor the letter of the law. DEI does not care for the principles on which our republic was founded. DEI does not consider the violent felon, nor does it comfort the victim of an attack. Instead, it looks to determine if the perpetrator is a minority or what in their background drove them to commit the crime. DEI does not care for the frustration of the veteran judge, who is now being pressured by activist lawyers to abandon blind justice in the name of equity. DEI is not only incompatible with Americanism, but it is incompatible with the study of law itself. Because DEI seeks to break down the laws, framing them as inherently racist. Because of Standard 303C, law students around our country are being taught that they must consider the law as an oppressive tool. This will inevitably lead to judicial activism where judges rule not based on the laws of our nation, but based on their own opinions of fairness. You might ask how an unelected organization forces every law school in America to adopt this worldview. The answer is extortion. The ABA leverages its monopoly over accreditation as a weapon. If a university does not bend to these diversity standards, they risk their accreditation, and their students risk the ability to sit for the bar exam. The ABA is acting as a cartel, enforcing an ideological tax on every future lawyer and every university that accepts federal funds. The American Bar Association has much to answer for, and it's high time that this monopoly be held accountable for the implosion of blind justice it has caused. They know they are in legal peril. They have quietly tried to backtrack on these radical standards since the Supreme Court struck down race-based admissions. But make no mistake, even though they scrubbed the language, the activist programs they created remain. We must work together to ensure that these standards of viewpoint discrimination, DEI, and critical race theories are removed from our law schools before it is too late. Thank you.
Thank you, and I want to once again thank the witnesses for being here. We're now going to move on to the question and answer portion of our hearing, and we'll begin with Chairman Jordan. I now recognize Chairman Jordan for 5 minutes for the purpose of...
Thank you, Mr. Chairman. Ms. Banky, a press statement, November 30th, 2023, headline reads, American Bar Association withdraws 2 statements on Israel-Hamas war. Why did the ABA withdraw those statements?
Congressman, I am the president and became the president last August. The process for either making statements or withdrawing statements, those particular statements happened outside of my time in presidency.
I understand that, but why did you do it? You're the president of the same association that withdrew the statements. You know why they did it?
Each year, when the ABA takes positions, they do so based on policy that has been adopted by
Who are the good guys in the Israel-Hamas war, Ms. Banky?
When we adopt policy...
No, that wasn't my question. I just asked you a new question. Who are the good guys in the Israel-Hamas war?
I have nothing to add other than we adopted policy. and
Simple
when we
question.
have-
Israel's our ally, one of our best friends. They were attacked on October 7th. One of these statements that was withdrawn by the ABA came out on October 9th, 2 days after women and children were killed and raped and taken hostage, villages destroyed. Israel's fighting a terrorist organization. I'm asking you a simple question. Who are the good guys, Israel or the terrorist organization?
The ABA adopted policy, and when the ABA adopts policy, then statements are issued, and those are the decisions that are.
I'm not
made
asking
by
about the statements
president.
right now. Forget the statements for a second. I'm asking you a simple question. Who do you want to win, Israel or the terrorist organization?
I have nothing further to add. My personal opinion is not relevant. I am here as the president of the American Bar Association.
You took statements down, statements that were issued 2 days after Israel was attacked. The statements were taken down because they were deeply flawed, because they suggested Israel was guilty of war crimes. That was ridiculous, and you took those statements down. Now I'm asking you, as the head of the Bar Association, who are the good guys in this conflict? Our friend and ally, Israel, or the terrorist organization, Hamas? This is not a trick question. It's actually a simple question.
I have nothing further to add.
You won't answer. Third sentence of your written testimony, you said that the American Bar Association is a nonpartisan organization. Is that really true?
Yes, sir, it is.
Really? Do you take any partisan positions as the American Bar Association?
The ABA takes position when our House of
The
Delegates.
association opposes any law that restricts abortion. This came out after the Dobbs decision. That's pretty partisan. The American Bar Association opposes detention of individuals who are here illegally. Any migrants who break our immigration laws, you oppose detention. Those sound pretty partisan positions to me. Would you agree?
The ABA takes positions by our House of Delegates, which is made up of 600 lawyers from across the country. When we take positions, we do so based on the information that we believe is.
How about men and women's sports? Do you have a position on that?
I don't have a list of all of our.
I'll read from the American Bar Association, adopted by the House of Delegates, August 9th, 2021 resolution. The American Bar Association opposes any federal, state, local, territorial, tribal regulation or policy that prohibits transgender students from participating in athletics in accordance with their gender identity. Sounds like you're for men and women's sports to me.
Our House of Delegates adopted a resolution based on the discussion and debate of our 600-member board or House of Delegates.
I've never heard of a nonpartisan organization that's for unrestricted abortion, no detention for people who break our immigration law, and who want men and women's sports. I've never heard of a nonpartisan organization adopt those positions. You still say you're nonpartisan?
I do, sir.
Wow, that's amazing. Nonpartisan, and won't tell us who you want to win the war, our ally or a terrorist organization. Mr. Smith, the marketplace has a way of speaking. How many lawyers do we have in the United States of America?
Several million.
Several million. Do you know how many are in the American Bar Association? I think it's like 1.5 million lawyers in the country. Some people might think that's too many. I don't know that that is or isn't, but 1.5 million, I think. How many do you know are in the Bar Association?
Members of the ABA, I don't know that number off the top.
Like 200 and some thousand. So most lawyers say, I don't want to join this nonpartisan organization. You think maybe it has something to do with their partisanship, why they don't want to join?
Well, I think that's the reason you're seeing state Supreme Courts moving away from having the ABA act as the gatekeeper for lawyers to be able to sit for their
Several states are doing that, right? Tennessee, Texas, Florida saying, we don't want these guys who can't even tell us that they want our ally to win a war, who take all kinds of left-wing positions and then pretend to be nonpartisan. We don't want them doing the accreditation for our law schools in our respective state. Is that accurate?
That is accurate.
Yeah, and I think it's the marketplace speaking. The American people, American lawyers are saying, no, we're tired of this left-wing operation.
Yes, I think that is accurate, Congressman.
I will yield back to the chairman.
Thank you, Chairman Jordan, and I now recognize Mr. Min for 5 minutes for the purpose of asking questions.
Thank you, Chair Gill, Ranking Member Simon, for hosting what appears to be a rerun of last week's hearing. Before I get into the substance of this hearing, I did want to just note again something that I think goes to the heart of the credibility of this particular hearing. This task force was created to defend constitutional rights and expose institutional abuses. We have myriad examples of this happening right now, the issues that my constituents are calling me about, whether it's the illegal war in Iran, whether it's the illegal abuses by ICE, real constitutional abuses. And instead of focusing on any of these actual constitutional abuses by President Trump, We were once again focused on DEI, diversity, equity, and inclusion. I also want to just note something just to show how unserious this hearing is. Ms. Banky, I just want to clarify, you're the president of the American Bar Association, the primary professional organization of lawyers in the United States. Is that correct?
That is correct.
Does the ABA accredit law schools?
The Council of Accreditation and Admissions to the Bar does the accreditation work, but that is separate and apart from the association as is required by the Department of
So
Education.
the Council of the ABA's section of legal education admissions, the council is responsible for accreditation, and that, as you noted, is a separate entity as required by the Department of Education. I want to apologize on behalf of this entire committee for wasting your time and inviting you here, because this is not supposed to be you, but someone from the council that should be addressing our committee. Is that correct?
The council is responsible for accreditation, so I can't speak on behalf of the council.
That's fair, and I think this is a failure of this committee showing how unserious this is, because we don't even understand apparently the basic structure of legal education. We're inviting the wrong witness to testify before this committee. This is not a minor failure. This is something that goes to the heart of this. This is a bunch of mistruths, half-truths, trying to create a smear campaign against the ABA and against law schools. Now, I was a law professor myself once upon a time. I actually served on our admissions committee at one point, and I have some familiarity with what happened here. And I just want to address Mr. Blackman. I had a chance to read your testimony, and I will just note, I don't know what the policies at Penn State Dickinson are, but at my law school, at every law school I'm aware of, it would be extremely inappropriate for a 1L student to write a message to every single person on the law school email list. Probably prohibited at my school. So I'm not sure why you think that's a suppression of your free speech. It really has nothing to do with the content of what you're saying. I would suspect that that is a policy matter of we don't want 1Ls addressing the entire law school community. Another point I would make to you in regards to your testimony, you make a great deal about how you were forced to take a class on race and the Equal Protection Clause. You understand, I know you didn't finish law school. You maybe finished a semester. That is a core part of the 14th Amendment. That is something that is taught in every con law class in every law school in America, right? I don't know why you thought that was so offensive, why that forced you to drop out of law school, but part of the law school pedagogy is addressing topics that we may not agree with. The idea here is to accustom us with understanding the other side's position, an integral part of being a lawyer. I wish you had taken more classes. I taught many conservative students. Some of them were among my best students, precisely because they challenged the orthodoxy of other students. They made other students uncomfortable, but in that process, they also learned to understand and empathize with opposing arguments. And that is a core part of the pedagogy here. Now, I want to just point out another problem here with this entire line of questioning and some of the testimony that we have read today, including from you, Mr. Smith. With one of the relevant cases that has governed basically my entire life on affirmative action, the 1978 Supreme Court decision in Regents UC versus Bakke. As we all know, I think we all know, the Supreme Court in this decision prohibited universities from using strict race-based quotas during the college or other admissions processes. They allowed race and other protected classes to be factors. But when I was on the admissions committee, this was before the decision in Harvard, we were allowed to use race as a factor. We were not allowed to actually have any kind of quotas. We could not say, for example, we don't have enough black students, we need to admit more. That would have been exactly illegal. Ms. Banky, I want to ask you, you're aware of the 2023 Supreme Court decision, Students for Fair Admissions versus Harvard, is that right?
Yes, I am.
And you know that in that decision, they held that UNC's and Harvard's race-conscious admissions practices were unconstitutional under the Equal Protection Clause and Title VI. Well, I would note that this ended race-based admissions, but did not actually eliminate all DEI practices. And what is still allowed to be quotas or to be factors in admissions, geographic diversity, something we know universities and law schools take great pride in. We can say we have people from rural Alabama as well as California. We also know that they're allowed to take ideological diversity into consideration. That is something that my law school took very seriously. We hired more conservatives. It was definitely a factor, people that needed a little bump up. We said, we don't have enough conservatives here on our faculty. We don't have enough conservatives in our student body. We admitted those students. We bumped up the faculty for that reason. And I would just note, just to close, that these practices of geographic and ideological diversity actually benefit kids, say, from rural Alabama conservatives much more than they do, say, Asian kids from Irvine. I don't know why we're focused on race and not on ideological geographic diversity. And with that, I yield back.
Gentleman's time. All right. I now recognize myself for 5 minutes for the purpose of asking questions. And Thank you to all of the witnesses, again, for taking the time to come before this hearing, which I think is incredibly important. Ms. Banky, according to the ABA's website, quote, all of us have implicit biases. Would you agree with that statement?
The ABA believes that diversity, equity, and inclusion improves the practice.
Would you agree with the statement that, quote, all of us have implicit biases from the ABA's website?
The ABA believes that diversity in all of
Is
its
that a
realms
yes?
is
Can I take
important.
that? It's a yes or no question. Do you believe that all of us have implicit biases, as your website says?
The ABA looks to remove barriers, and we examine.
That's not my question, ma'am. Do you believe that all of us have implicit biases?
I've expressed what the
You do.
ABA is doing.
That
with
is
its
that is the
diversity work.
ABA's position, as expressed by their website. Against which groups do you have implicit biases?
The ABA believes that it's important to always explore.
Are you going to filibuster? Because it doesn't make you sound very good. I'm going to ask you again, against which groups do you have implicit biases?
It's important to always examine everyone's point of view and where they may need to
It
consider.
is. What about your point of view?
I am here as the president of the American Bar Association, and so
And I'm asking you what your implicit biases are.
the ABA as an entity.
Have you reflected on your implicit biases?
I think about how I
are
operate
they?
the world constantly.
Would you like to explain to us what they are?
I am here speaking on behalf of the ABA and the
All right,
ABA's.
we're going to move on. Was race a factor in Ketanji Brown Jackson's Supreme Court nomination?
I have no idea how that process works. I'm a real estate lawyer.
President
from Madison, Wisconsin.
Biden stated, quote, I've made no decision except one, and that's that person will be the first black woman ever nominated to the United States Supreme Court. So I think it's fair to say that race was and gender were factors in that nomination process. Wouldn't you agree?
You would have to have a conversation.
He explicitly stated that, so I think it's fair to say. I mean, you're a lawyer. I think that's fair to say. Do you think that it's just or righteous that Joe Biden explicitly excluded black men in the nomination process for the Supreme Court vacancy?
The ABA does not support discrimination of any sort.
So you don't think that it was proper for Joe Biden to exclude every group other than black women in deciding who should fill that Supreme Court vacancy? Is that your testimony?
The ABA relishes diversity, equity, and
Right, but
inclusion.
is
and
it
bringing-
acceptable for Joe Biden to exclude black men in the nomination pool for the Supreme Court?
The ABA never supports discrimination.
That's good to hear. And you believe, I think, tell me if that the Supreme Court should roughly resemble the racial diversity of the country?
The ABA does not believe that quotas are appropriate. It is
According to the ABA's mission statement on its website, it states that judges, it increases the quality of our judicial system whenever judges resemble the vast racial diversity of our society. So would you say that it's helpful, it's beneficial if our Supreme Court resembles the racial diversity of America?
The ABA believes that diversity in all of its forms is important. We
So it
want
is a
people to
good
bring
thing.
all of who they are, whether they be from small practice or
Diversity,
large practice.
can you define diversity here? You want it to, should the Supreme Court resemble America's racial makeup, roughly? It's a yes or no question.
The ABA does not support quotas.
I'm not asking about quotas. I'm asking if it should roughly resemble America's racial makeup.
It should represent all of what people are.
Of
and
what
all
people
their
are, okay. So
experiences.
right now, there's about two of nine of Supreme Court justices are black. That's about 22% of the Supreme Court. According to your testimony, about 13% of America's population is black. If the Supreme Court should roughly resemble America's demographic makeup, as the ABA states is proper, in your opinion, regardless of qualifications, should the Senate refuse to confirm a third black Supreme Court justice?
The ABA supports and encourages diversity in all of its forms.
That wasn't my question. My question was, if a Supreme Court vacancy opens up, should the Senate refuse to confirm a third black Supreme Court nominee based on his race or her race?
The ABA does not support quotas, and so.
The ABA does
a hypothet-
support some sort of, and hopefully we'll get into that The ABA does support making sure the ethnic makeup has a specific amount. But my time is up, so we will move on. And with that, I yield. I recognize Mr. Walkinshaw for 5 minutes.
Thank you, Mr. Chairman. Constance Baker Motley, she was a Columbia Law School graduate, the first black woman to argue before the Supreme Court, the first female attorney at the NAACP Legal Defense and Education Fund, where she became a lead trial attorney in consequential early civil rights cases. She represented Dr. Martin Luther King Jr. She wrote the original complaint in Brown versus Board of Education and Meredith versus Fair. She won the case that resulted in James Meredith becoming the first black student to attend the University of Mississippi. She was later an elected official, a federal district court judge. Ms. Banky, you have dedicated your career both to the legal profession and to expanding access to that profession. I want to thank you for your service and for being here today. The supposed purpose of our task force here is to defend constitutional rights and expose institutional abuses. Your testimony emphasizes the ABA is deeply committed both to ensuring diversity within the legal profession and to preserving the rule of law. And I can think of no better example than Judge Motley to demonstrate why those commitments are closely connected and how together they can help us defend our constitutional rights and expose institutional abuses, what this task force is supposed to do. Because diversity in the legal profession isn't just about who's present or who gets admitted to a law school classroom or hired at a law firm. It's about ensuring that people from every background, liberal, conservative, urban, rural, male, female, every background, have a seat at the table, an opportunity to use the law to identify and challenge abuses of power, because people who have witnessed institutional abuse or experienced it or come from communities whose rights have historically been denied might recognize an injustice that others overlook. And a legal education can give them the tools to challenge those injustices, hold those institutions accountable, and prevent abuses from continuing. I think that's a concept that this administration and some of my colleagues are terrified by, quite frankly. Judge Motley broke barriers, she strengthened the profession, she forced powerful institutions to abide by the rule of law and the Constitution. She made our country greater. That's exactly why diversity in the legal profession matters. A system that draws its lawyers, judges, public officials from every background is better equipped to recognize institutional abuses and to end them. So unfortunately, I don't think this hearing is about defending constitutional rights or exposing institutional abuses. I think it's about making it harder for women and people of color to pursue a legal education, making it harder for them to get the tools required to protect their own rights, protect all of our rights, and expose abuse. Ms. Banky, from your experience as a law student, a lawyer, the president of the State Bar of Wisconsin, if I have that right, and now the president of the ABA, can you speak to how diversity in all its forms in the legal profession can help defend Americans' constitutional rights and prevent institutional abuses? How can diversity help us to accomplish those really important goals?
When you have a diverse group, people who have different experiences, people who have looked at the issue from different ways, that helps expand the problem solving. There are studies that have been done by McKinsey and Harvard Business Review who indicate that the more diverse a team is, the better the solutions are. And at the end of the day, lawyers are there to solve their clients' problems, to solve the issues that face our society in the way of legal issues. And so when you have a diverse group, you have better outcomes, and when you have better outcomes, then the public as well as the particular clients have greater confidence in the system.
Yeah, I couldn't agree more. Look, I've been on a lot of teams in my life, sports teams, professional offices, organizations, boards, committees, commissions. In every single case, I have found that those teams are stronger when there's a diversity of perspectives and backgrounds and views. And I don't understand how we got to a point in this country where there are people in very high positions of power so terrified by that. Mr. Chairman, I yield back.
Thank you, Mr. Walkinshaw. I now recognize Mr. Cloud for 5 minutes for the purpose of asking questions.
Thank you, Chairman, and thank you for holding this hearing. You say that the American Bar Association is nonpartisan. That's correct. You maintain that as your testimony today.
Yes, sir.
Yet, when we look at the amicus briefs filed over the last 10 years by the ABA, 87 briefs have been filed. 80% of the organizations filing advocated for liberal and progressive outcomes. Only 21% of the ABA's briefs concern matters directly related to the legal profession. Of 87 briefs filed over the 10-year period, 70 favor liberal progressive outcomes, 17 were genuinely neutral in nature, and 0 can be characterized as conservative aligned. Why is that?
When the ABA files an amicus, we can only do so when 2 factors are in existence. First, the ABA has to have policy. That policy is developed by our House of Delegates, which is made up of 600 members from across this country, every state in the union, red states and blue states. So first, we have to have policy. Then, if we are requested to file an amicus, we have to determine that we have something unique to offer the court in assisting it in making its decision. When we file an amicus, then we are doing so based on the existing policy. We don't line them up based on liberal or conservative.
It seems like whether you were intending to or not, the net result is the fact that your work product is very much liberal leaning, if not progressively imposing or working toward those advances. It's not at all any sort of nonpartisan or, in a way, a gatekeeper of making sure that the legal profession is respected and protected.
Our policies are the issues that are raised by our members. Anyone within the House of Delegates can raise an issue, can speak to and debate an issue, and bring resolutions. So when we decide—
Do you think transgender surgery for minors is a nonpartisan issue?
The ABA developed policy on that issue, and therefore, going through that process—
That is one issue where I think there is it crosses, maybe not here in Congress, but the American people are very much against transgender surgeries for minors. Yet the ABA is supportive of that.
Our policy is developed by our House of Delegates with those members from each and every state, sir.
It doesn't concern you that you're that far off from the American people?
The policy that is developed in our House of Delegates is done through a very deliberative process, and when those issues come up and are voted on, that is what sets our policy.
Okay, the ABA supported the disbarment of a number of lawyers who defended President Trump. Yet we had other lawyers who actually campaigned in going after the president, kind of invented new and novel legal parameters to create a prosecution case against him. We've seen no disciplinary action taken against those individuals. We haven't seen the American Bar Association support the disbarring of them. You know, again, we're seeing kind of like a left-leaning approach by the ABA.
I'm not aware of what you're speaking about in terms of disbarring lawyers. The ABA is an association.
Aware?
We are not, we do not actually control the barring of lawyers, each individual.
No, but you put out statements supporting it.
I'm not aware of any statements that support disbarring particular lawyers.
Mr. Smith, you've done some work and study on this. The ABA, in a sense, acts as a gatekeeper. Yes, there's a little bit of a divide between the Accreditation Council, but you know, there's a lot of overlap there as well, and as far as how the members of that council are selected. Could you speak to that? And really, should we have one organization kind of being the gatekeeper, or should the Department of Ed look at multiple institutions, or would it be better left to the states?
Yeah, thank you for that question, Congressman. The Department of Education absolutely should authorize more law school accreditors than one monopolistic entity. Now, when it comes to the Council of the ABA's section of legal education, there is a lot of overlap. The council would not exist without the ABA. In order to be a member of the council, you first have to be a member of the ABA, except for a few public members. The officers of the ABA's section of legal education and admissions to the bar automatically are members of the council, the accrediting entity. And so, as I mentioned in my opening statement, there is a lot of overlap between the big ABA and the council that does the accrediting.
So sitting here and saying, oh, there's no overlap, I can't speak to that, it's probably not exactly accurate.
There is more overlap than I think that statement reflects.
Gentleman's time has expired. Now recognize Ranking Member Simon for 5 minutes for the purpose of asking questions.
Thank you, Mr. Chairman, and again, thank you to our witnesses. Today, the task force has decided to hold yet another hearing on diversity and the horrors of inclusion, the horrors of equity. After we had this same hearing last week, we also know that the DOGE subcommittee just had a hearing on this exact topic just yesterday. And I think the American people deserve to know why the majority is so concerned about inclusion and equity, that we need to have back-to-back hearings on the issue. At last week's task force meeting, each witness testified in no uncertain terms that the so-called DEI crisis are the reasons for Americans' families suffering, paying more for groceries and gas under the current administration's policies. They were all very clear about that. This is why the task force is dead set on ignoring the challenges of what's affecting Americans who are hurting the most. I know in my state, in my district, one of the largest states in the country, I think the chairman's state is also, well, actually the largest, we have real issues in both of our states. In my district alone, there's over 1,000 veterans that are sleeping on the street. I don't care what party you belong to, we know that that is wrong. I know that in my colleague's district, Texas has led the nation in hunger over the past 2 years, with more than 5 million Texans unable to afford enough to eat. In the Dallas area alone, gas prices have risen by almost $1 over the past year. From Texas to California, our constituents are worried about how they're going to pay for gas and groceries and healthcare, and are worried about how they're going to pick up their kids from the daycare that they can't afford and use that gas and hustle it to get to work the same day. But we're here today, hours. People flew in. We're here to talk about law school accreditation, and today's hearing is not also about restoring merit to the law school accreditation process. We know that. Mr. Smith, I gave you a quick hint in my opening statement, but do you know how many people applied to ABA accredited law schools last academic year?
Well, I would imagine the majority of applicants applied to ABA-accredited law schools because historically, the ABA has been the only law school accreditor, and historically, states have required...
My time is so limited. It's about 77,000 people. Do you know, 77,000, remember that number. Do you know what the percentage of the American population that is?
I do not, Congresswoman.
It's about 0.02%. Mr. Smith, do you know the percentage of law school applicants that are people of color of that 77,000?
The process, Congresswoman, should be open equally to all.
I will claim my time. What's important to know, because we're talking about de-diversifying, challenging inclusion and challenging equity. Half of the law school applications for the last academic year were people of color. So do you know what percentage of the American population that is?
Congresswoman.
I'll answer it. It's 0.01%. 0.01%. So let's bring this issue home. We're here at a hearing on law school accreditation, and the Republicans have invited the ABA president, and thank you for your presence today, knowing, they've had to know that her position doesn't play a role in law school accreditation. Maybe the majority just made an honest mistake, but I'm still trying to figure out what we're doing here. So why has President Trump consistently attacked the legal profession since he's returned to office? We know why. This is an unprecedented executive order spree that we have seen retaliating against specific lawyers and law firms. I yield back.
Thank you, Ranking Member Simon, and I now yield 5 minutes to Mr. Jack from Georgia.
Well, thank you, Mr. Chairman. I appreciate you convening this task force today, and I myself, as well as many of my constituents who are watching, reached out to let me know how impressed they were with your line of questioning. So with that having been said, I'd like to yield the remainder of my time to our distinguished chairman, Mr. Gill.
Well, thank you. I appreciate that. Ms. Benke, let's pick up where we left off before. The mission statement on the ABA's website states that our legal profession is enhanced when judges resemble the cultural groups that make up American society. How many Supreme Court justices have we had in American history?
I could not tell you over the
It's about 116. Do you know of those 116, how many of them have been transgender?
I have no idea.
Do you think there might have been one?
I have no idea.
Is it fair to say that there have been no transgender Supreme Court justices in American history?
I honestly have no idea.
You don't know?
I have no idea.
You study the law, don't you?
We do not study the personal attributes of individual justices.
Is there a Supreme Court justice in American history that you think might have been transgender?
I have no idea.
You have no idea? Well, I think most people can assume that there haven't been any transgender Supreme Court justices. I hope that we can agree at least on that basis. Would that be okay to proceed under that assumption? Okay. I appreciate that. So transgenders haven't been represented on the Supreme Court. Do you think that it's important that the next Supreme Court justice be transgender?
The ABA does not subscribe to any particular quotas.
I'm not asking about a quota. I'm asking about representation, diversity, equity, and inclusion.
The ABA supports diversity in all of its forms, and
Have transgenders been included on the U.S. Supreme Court?
the ABA supports the full spectrum of
Do you think that it's
diversity,
a
and we
problem
think
that the transgender community has never had representation on the U.S. Supreme Court?
the ABA believes in diversity, equity, and inclusion as
And I'm
something-
asking you about diversity, equity, and inclusion. I'm asking you about inclusion of the transgender community.
We believe that people ought to bring their entire self to whatever role they're serving.
You're
in the
refusing to answer my question. Do you think that it's important that we have a transgender Supreme Court justice
I believe that it's
in order to
important.
include that community?
I believe that it is always important, the ABA believes that it is always important to support and encourage diversity,
So we
equity,
should
and
have a
inclusion.
transgender Supreme Court justice?
Diversity has many forms, and we believe that
Do you think
each
that you're not
person-
answering in a straightforward way? Do you think that's because of your own implicit bias?
I believe that I'm trying to explain that the ABA does not set quotas and does not believe that
Do you have
need
implicit
one-
transphobia?
The ABA believes that diversity in all of its forms is important and helps the profession more globally.
Okay, we're going to move on. Should Americans be judged by the color of their skin or the content of their character?
Discrimination is never appropriate, sir.
So do you agree that Americans should be judged by the content of their character and not by the color of their skin?
Yes, I would agree.
You agree with that? Should a law school consider an applicant's race when making admissions decisions?
The Supreme Court has indicated that
I'm asking you if they should. It's a normative question.
discrimination is never appropriate, and
So is it your testimony that law schools should not consider applicants' race when making admissions decisions?
the Supreme Court has said that you may not take race into account.
So you don't believe that race should have any role, yes or no, in a law school's admissions decisions?
Law
Is that the position of the ABA?
The ABA is not responsible for admissions.
I didn't say it was. I'm asking you if you if you believe, and if it's the position of the ABA, that race should not be a factor at all in a law school's admissions decisions.
The ABA takes compliance with the law seriously.
I didn't ask you that. I asked, it's a really simple question. I'm asking you, let me just ask you, in your own personal capacity, should race be a factor in law school admissions decisions? The question is a yes or no question.
I am here in my
Yes or no,
capacity-
should race be a factor
I
in
am-
law school admissions
I am
decisions?
here in my capacity.
Because according to the ABA, it should. The ABA has said explicitly that they have a long history of supporting consideration of race in law school admissions. Is that your testimony, that law schools should continue taking into account race?
The Supreme Court indicated that diversity is a laudable goal, and the ABA supports diversity in all of its
This is
forms.
embarrassing for you. You ought to be able to answer this in a very straightforward way. And with that, the time is up.
Sir, I have 3 UCs request.
Go for it.
Thank you. I ask unanimous consent to enter into the record a July 2026 article from Kerner News, North Texas families and the summer food programs they rely
Without
on
objection?
are feeling the sting of inflation.
Without objection. All right, and we're going to skip closing because we've got votes now. So in closing, I want to thank the witnesses once again for their testimony today. Appreciate it. Thank you all for coming.